Greetings to all dear colleagues, the public, and the candidates. Today, on January 16, 2025, the advisory group of experts gathered in full to conduct an interview with a candidate for the position of judge of the Constitutional Court of Ukraine, Zakhar Tropin. In particular, the present advisory group of expert members are with us Alice Zeller, Yaroslav Romyuk, Vasil Shukhin, as well as myself, the AG Secretary Maureen O'Connor. We also have Hannah Zahukka. I would also like to draw the attention to the fact that AG member Oksana Vasilchenko took a self-recusal in relation to the candidate, Mr. Tropin. Therefore, according to the law of Ukraine on the Constitutional Court of Ukraine and the AGE regulations, the deputy member of the AGE, Vitaly Mahunchik, who is also present, performs the powers of a member of the AGE to evaluate the candidate, Mr. Tropin. Also, during the interview, the rest of the AG deputy members are present. We have Thomas Griffith, we have Richard Barrett, Vladimir Kuzmenko. I note that we work in a shelter, so in the event of an air raid, the interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the resources of the advisory group of experts and the website of the Constitutional Court of Ukraine. Therefore, I draw the attention of the members of the AGE and the candidate regarding the restriction of the use of sensitive data and information with limited access live. If it is necessary to discuss such issues, the AGE will limit the broadcast at that time. Let me remind you that the opportunity for an in-person interview is a mandatory stage of evaluating candidates as part of the assessing their compliance with the criterion of high moral qualities. One interview is given up to 1 hour approximately, and the time limit for answering questions is 3 minutes. Traditionally, we ask all candidates to be concise and to answer clearly, unambiguously, and to the essence of the questions asked. At the end of the interview, the candidate can make a short final statement up to 5 minutes. We would also like to note that during the processing of materials about candidate Tropin, the AGE sent him questions to provide written explanations so the candidate had the opportunity to prepare and provide answers. So now we have with us a candidate for the position of the judge of the Constitutional Court of Ukraine, Zakhar Tropin, who was admitted to the competitive selection by the Committee of the Verkhovna Rada of Ukraine. Mr. Tropin is the director of the Department of International Cooperation and Representative Office of the Ministry of Justice of Ukraine. He is also a PhD in law, associate professor, and works part-time at the Department of International Law at the Educational and Scientific Institute of International Relations of Taras Shevchenko National University of Kyiv. Mr. Tropin, if you want to add something to your presentation, you can do it now with 2 to 3 minutes.
The only thing I can add that I also have more than 17 years of teaching as a professor, Department International Law.
So colleagues, we'll start with Ms. Zukowska, and you may proceed, Hannah.
Yes, thank you. Thank you, Maureen, so much. I will start with the first question. The first question concerns the non-declaration of income. In the section income, including gifts of the declarations for 2019, you indicated that you received hryvnia 326,000 of wage as your main place of work at Taras Shevchenko National University. At the same time, according to the State Register of Individual Taxpayers, in 2019, you also received grivna 5,976 from the State Higher Educational Institution, Uzhhorod National University, and then another sum from the State Educational and Scientific Institution of Postgraduate Education, Diplomatic Academy of Ukraine, named after Gennady Yudovenko, and also 340 grivna from the State Enterprise Information and Image Center, and 2,515 grivnas from the Western Ukrainian National University. Such income was not reflected in your declaration for 2019. How you can indicate why you didn't include these incomes to your declarations for 2019? That's my question.
Хочу відзначити, що на
I would like to note and say that back then I was not the person who subject to declaring, and the specified declaration was submitted by me as the candidate for the position to the office of the Prosecutor General. And given the very limited time, since I learned about that competition very late, I had to prepare these documents very fast, so I had to fill out this declaration very quickly. And actually, in the process of filling it out, I was also familiarizing myself with the rules to fill it out. Therefore, I did not have enough time to fill it out completely and to full extent before the moment I had to submit the documents for the participation. So I decided to fill it out partially, or at least as much as I could, having that information, in order to later on give the clarified data. But then when I found out that I also had to obtain additional certificates on the income, confirming the income that I specified, and additionally study the order for submitting the declaration, since there were many mistakes that I made also in the part of the position that I was applying for. If you study the declaration, I have made a lot of mistakes. Also in the part of the intellectual property rights, because by mistake I have indicated my scientific papers that were not supposed to be specified there. I decided, not to continue my participation in the competition, and I automatically was excluded from the competition. I decided not to even correct that declaration. That's all.
Making such a lot of mistakes is exactly how to say. You can say that something I did many mistakes. You start for being a judge in Constitutional Court. If you are making so many mistakes in your declarations, how you can be I don't know, a good judge? That's my question. Yeah. What do you think? Why did you make so many mistakes in different areas? Incomes, your intellectual property, etc.
Як я вже казав,
As I have already explained, I thought I would have time to correct the mistakes, to rectify it. So in order just to fulfill this formal requirements for me to be able to submit the documents, I submitted that declaration in that form and information that I had in my hands. And later, I was thinking that I would enter the adjustment once I obtained that information. But when I realized that I would not be able to do it in time, I left it the way it was. And by the way, this was a very interesting experience for me that I was using when I was filling out the declaration for this competition, for the position of the judge of the Constitutional Court of Ukraine. I am convinced that that declaration was submitted by me with no mistakes.
Okay, thank you. Now I think that Vitaly will make the next questions.
Дякую. Пане Захар, друге питання.
Thank you. So second question refers to the privatization of an apartment, of your apartment. According to your declaration for 2023, you are the owner of an apartment in Kiev on the Tichine Avenue. According to the data available to the advisory group, you and your mother privatized this apartment in equal shares in 2004, after which your mother in 2021 gifted you with her 1/2 share in the ownership right. So the question is, do you confirm this information? Yes, I do. From the title documents, it can be seen that the said apartment was managed by the Department of Affairs of the Verkhovna Rada of Ukraine. So we have the question, what did you and or your mother have to do with the Verkhovna Rada of Ukraine? as members of the family of the MP, because back then my father was an MP, member of the parliament, I mean, as of 1998 up until 2002. So he had the right to get the accommodation in Kiev, and us as members of his family, we also got this accommodation. Thank you. So my next question. In this case, why did your father not participate in the privatization of this apartment? Because he has exercised his right for privatization before this one. He has privatized the apartment in Sumy city. Did your father live in this apartment, and did you live with your father and mother in the same family at that time? Yes. Yes, for the moment of the privatization, yes, we did live together. So the question is, how did you manage to privatize an apartment that belonged to the housing stock of the Department of Affairs of the Verkhovna Rada of Ukraine if your father did not participate in the privatization? If I'm not mistaken, according to the legislation about the privatization, the right for privatization is given to the persons who live in the specific housing. So if my father's right has already been exercised, so me and my mother, we have exercised our right for privatization. Did this apartment have the status of official housing? As far as I remember, no. No, I can tell you for sure, no, it did not have the status of the official housing, because I have communicated with my parents, and when we were moving in, it did not have the status of the official housing. That's why we got the order that I have provided to the commission. If I'm not mistaken, when you move into the official housing, you get another document. And also another thing, the official housing means that it's completely furnished, like having furniture, TV, fridge, everything. So the one that is suitable for living in it. And I remember exactly when we were moving in, nothing like that was there. We had to repair it, and it did not have the status of official housing. Thank you. What were the grounds for allocating you an apartment with an area of 81 square meters? What was the calculation made in that case? Well, first of all, it is necessary to divide the right for privatization and the right for allocating the apartment. In the part for allocating right, it was still considered given the quantity of persons, 3 persons, me, my mother, and my father. Plus, according to the legislation at that moment of time, when allocating an apartment, if the family has 1 or 2 candidates of sciences, then 2 rooms were supposed to be allocated. I remember this very well, because when we were getting our apartment in Sumy, this was a matter of jokes in our family that we had the right for 1 more room. And if I'm not mistaken, another thing is envisaged, and that is 3 persons as a family, and they should get additional square meters, since my parents, both parents, are both candidates of sciences and associate professors, so they both were supposed to be allocated with the square meters. If we actually calculated, it would actually go even higher than 81 square meters. Thank you. Have you exercised your rights to privatization over the norms? Since in that apartment there 3 persons lived. Yes, I think this was over the norm, and when I was answering the questions in the written form, yes, it was exercising rights over the norms. So it was allowed to have 21 square meters plus 10 per family, so that equals 50. So 30 square meters was over the norm. So in this case, if this privatization was over the norm, did you make any additional payment for the area that exceeded the privatization rate? Back then, this was on the control of my parents, and we don't have the documents. But as far as I understand, yes, some additional payment was made. Because it couldn't have been any otherwise. We wouldn't be able to privatize it otherwise. Dear colleagues, do you have questions on this section? Vasil Ivanovich? No, no questions. Thank you. Then let's proceed. We have the section of questions that perhaps presupposes closing broadcast, but it's up to you. This section refers to transactions aimed at the potential deprivation of the right of ownership of another person. So these questions will refer to your apartment in Chernihiv city.
Register of Attorneys of Ukraine, the address of your workplace is an apartment on Shevchenko Avenue in Sumy. In your answers to the written question of the advisory group, you noted that now this apartment does not belong to you on any of the property rights, and also for a long time it has not belonged to your father. Do you confirm this information which you sent to us?
Так, підтверджую.
Yes.
Yes, I do.
For what reasons do you not update your data in this register? We have always the question concerning the mistake in making register. Yes, how you can explain?
Дані
The data in this register were filled out once I passed the bar exam and received the license for practicing law. So this data was filled out according to the previous legislation that was amended in 2012, if I'm not mistaken. Accordingly, at that time, when this data was filled out, there were no requirements regarding updating the workplace address in the register. And this is quite a common situation when the attorney would be registered in a certain region and would be practicing law in a different region. This was typical for Kyiv. This was also typical for Sumy. After 2012, once the new requirements came into power, the updates of workplace address were still not an easy procedure to do, and you needed to prove that the updates of this workplace address were as the result of switching the place of practicing law. So for me, that was from Sumy to Kyiv. Therefore, I had to take the transfer notice. I had to go to Sumy multiple times, then go back to Kyiv and present this notice. And you do not have sufficient time to present this document in the proper way. So it did take some time, and due to high workload, I was not able to do this. At the same time, once the new requirements came into power, a certain tension appeared among the attorneys in Kyiv, and if I'm not mistaken, during the next 6 to 7 years, there were significant tense situations between the Central Department of Attorney's Office of Kyiv and the regional office. Therefore, in this case, for me to transfer my documents to the place where it was problematic would not be efficient for me and would not allow me to practice law as efficiently as I wanted. I do agree that after this, I was supposed to update this data in the Unified Register of Advocates of Ukraine, but I just got used to this. I did not pay enough attention to this, so I just let it slip. I do acknowledge that I was not diligent enough in updating the data in the Unified Register. Now I'm not able to do this physically since the license for practicing law is currently suspended.
Yes, for the moment, yes, but do you see that it was a violation of the requirements of Article 17 of the law in Ukraine on bar and attorneys' activity in terms of the need to maintain the relevance of the data contained in the register, yes? So you how to say, violated the requirement of the law at the time.
Я погоджуюсь.
Yes, I do understand that I made a violation of the requirements of Article 17, but when this law came into power, I was already violating it. So obviously, due to the situation with the high workload and the attorney's office in Kyiv, I did not do this the proper way. I was supposed to correct this and to update the data, but I was not diligent enough to do this.
Thank you. I have no more questions. Mrs. Roria.
Колеги, є питання
No,
до
but
Dear colleagues, any other questions? Any other questions within this block of questions? Mr. Zakhar, we move on to the next block of the questions related to your work in the Competition Commission. You were a member and also for some time a chairman of the Competition Commission for the selection of candidates for the appointment of a member of the High Council of Justice by the President of Ukraine. Do you confirm this information? Yes, I do. Tell us about the circumstances of your appointment to this position. Who exactly provided you with the recommendation for appointment? I am not sure who provided me with the recommendation or who helped me to get this appointment. I do have some assumptions regarding how this worked out or who could be involved in this. Before I learned about the order of the president that I was appointed as the chairman of the commission, I only had 2 discussions that were relevant to the topic of this appointment and to the topic of competition commission. So if we go back, it was May or June 2020 when I received a phone call from the Office of the President of Ukraine, and I was asked whether I would like to join the Competition Commission, and they asked me to provide my biographical data as well as the list of my scientific publications, and after that the order was issued. Before this, I only talked about this at the Faculty of International Relationship in December 2021, January 2022. This was not the discussion with me as a potential candidate. This was just a friendly discussion, friendly dialogue in between the lectures. So it was quite a chaotic setting. This topic was simply mentioned by some representatives of the faculty, and somebody said that they were looking for the new members of the Competition Commission, and one of the colleagues mentioned that I was the secretary of the special council, namely that I have relevant experience in organizing these structures, so I could be a potential candidate for this. That's it. That's the only communication I had on this point. Do we have any other questions within this block, dear colleagues? If no, then let's continue. According to information from the website of the President of Ukraine, on July the 3rd, 2024, the Competition Commission decided not to recommend the appointment by the President of Ukraine to the post of a member of the High Council of Justice and any of the candidates recommended by the Ethics Council. These candidates were Andrei Zhuk and Dmytro Davidchuk. Do you confirm this information? Yes, I do. Next question. In accordance with the law of Ukraine on the High Council of Justice, the Competition Commission conducts an interview with a candidate who has passed a special examination and is included in the list of candidates recommended by the Ethics Council for appointment to the position of a member of the High Council of Justice. Based on the results of the interview, the Competition Commission compiles a list of candidates recommended for appointment by the President of Ukraine to the position of a member of the High Council of Justice. Therefore, AGE has the following questions. Do you think that in view of these provisions of the law, the Competition Commission has the authority at its own discretion not to recommend candidates for appointment by the President of Ukraine to the position of a member of the High Council of Justice? This is not my position. This is the interpretation of the law. If the Competition Commission believes that a certain candidate cannot be recommended for appointment, or all candidates cannot be recommended, there is no other option. They are either recommended or they are not recommended. If they're recommended, they're included in the compiled list. If no, they're not included in the list. There is no other interpretation of this law. What was the reason for not recommending Supreme Court Judge Andrei Zhuk and Dmytro Dovachuk, both of whom have over 20 years of experience? Were they found to not meet the criteria of professional competence? At this point, the Competition Commission was conducting the interview to identify professional competence. According to the protocol of the interview, when assessing one's professional competence, if I'm not mistaken, there are 4 criteria included: motivation, professional experience of the candidate, knowledge of the law and legislation, and lastly, understanding of the structure, the goals and activities of the High Council of Justice. I believe it's something like that. Therefore, after the interview, according to this criteria, the Commission decided that we cannot recommend these candidates. Thank you. How many Competition Commission members were there at the time of making this decision? Do you remember the voting, how the votes were distributed? This was a homogeneous vote. Everybody voted the same. Dear colleagues, any other questions here? I would also like to add a comment here, if you allow me. It is important to understand that the Competition Commission has the right to make the decision in 2 stages. The first stage is studying the documents provided by the candidate, and at this stage, the Competition Commission decides whether the candidate and the documents he or she provided comply with the law. In this case, the Competition Commission can say whether the documentation complies or not. Therefore, if the decision is negative, the candidate is eliminated from the competition. And if we speak about the recommendation of the candidate, we can also provide the document with where the non-recommendation is specified. Thank you, Mr. Zakhar. According to the information that we have, Competition Commission did not inform Andrei Zhuk and Dmytro Dovachuk about the decision and the adoption and motives for making such a decision. Do you confirm this information? That's a tricky question. They were not informed properly. According to the procedure of the competition, after the decision on recommendation or non-recommendation is made, the candidates are not informed individually. The announcement is posted on the website of the Office of the President. And the same applies to the cases when the Commission decides to eliminate the candidate from the competition. In the first case, the Commission informs the candidates individually. And when we made the decisions of eliminating the candidates based on their documentation, we informed them individually according to the procedure of the competition. Now, if the Commission already makes the decision on recommending or not recommending the candidate, the candidates are informed with the announcement on the website of the President. We follow the procedure prescribed in the law.
Do I understand you correctly? So the information is published on the website of the Office of the President. Yes, on this stage. Yes, thank you. Thank you. We have a few more questions about the Competition Commission and your role there. From the article of the journalist of Slistvo Info, it can be seen that they first turned to the deputy head of the office of the president, Irina Mudra, for a comment on this situation, who in turn redirected them to the members of the Competition Commission. The Commission members replied to journalists that they could not speak for themselves and only you, as their head, could comment. In turn, you refused to comment on this topic and explained the position of the Competition Commission on separate candidates. Do you confirm this information? Yes, I do confirm. In the part that the members of the Competition Commission, they refused to provide comments and they redirected the journalist to ask this question to me. When I often get many requests to give the interview. I cannot remember exactly if the journalist of Slistva Info came to me to comment on this, but I guess I will trust the information from the journalist that they did. In this situation, the position of the Commission that made the decision, any external communication of the Commission is only done via the head of the Commission. That's the first statement. Second statement, any explanations on the decisions of the Commission only provided in the official manner. So if the Slistvo Info wanted to get information, they had to use the official procedure and to contact the Commission. And as far as I remember, they did not do it. Dear colleagues, any other questions on this section? No. Okay, let's proceed to our next question. As we know, the reform of the process of selecting candidates for the positions of members of the High Council of Justice, as well as the role of the Ethics Council in this process, were one of the key requirements on the way to Ukraine's European integration. Don't you think that such decisions of the Competition Commission could unreasonably hold back the implementation of the reform of the High Council of Justice? Well, first of all, I disagree with the phrase unreasonable and the word unreasonable, because the decision of the Commission were reasonable and made in compliance with the legal acts, norms, regulations, and second of all, this question seems strange to me, because what is the alternative? To automatically approve the decisions of the Ethics Council? Well, sorry, but this is not the aim of the law on the HCJ and the procedure for selecting candidates. So decisions were made in accordance with the legal documents, and they are reasonable. So they could not hold back the reform of the High Council of Justice. Are you still the member of the Commission? No. No. I have submitted the application, and it was considered at the meeting. If I'm not mistaken, it was August this year. What were the motives of you deciding to resign as the chairman? I was not hiding my motives, and it's back from the moment of transferring to civil service. I thought that me being as a civil servant, I was also the member of the Commission, because there were no legal obstacles to do so. And even in the view of the conflict of interests. But from the ethical point of view, for me, this was not comfortable situation for me that I wanted to tackle by resigning. But on the other hand, I couldn't do it because the competition was coming to its end, and it would take maybe 1 or 2 months until the documents would be sent by the Ethics Council on their consideration of the candidate. So I had my dilemmas, my internal thinking that from the ethical point of view I had to quit the Commission, but on the other hand I had the duty to complete the competition. So right after we have finished the competition, I have resigned. Thank you. Dear colleagues, any other questions?
question.
Да, будь ласка,
Because, you
пані
know,
Анна.
you made such a, I can say, authoritarian interpretation of the role of the competition commission. And it's a very complicated issue as you, how to say, inform us on the role of the competition commission. I remember very well because I was involved as a member of the Venice Commission in work on this law and the relationships between different bodies, ethical commission, high judicial commission, and competition commission. And it was seen rather as a very technical body, this competition commission, not as a decisive body. You have to prepare the list. And now you make such an interpretation.
Я перепрошую, це співбесіда з кандидатом чи
Sorry, is this the is this the interview with the candidate, or are we discussing the provisions of the Ukrainian legislation?
This interview with candidate because I would like to ask him question because he made such an interpretation which could be sometimes, how to say, erroneous for many members. They don't know, were not so strongly involved in the work on the institution. We have to know what is the right of the institution and what is the right of the person being a member of such a commission. To make, because then I am of the opinion that the information we received was wrong information. So I would like to verify again the answer which has been given by the candidate. And I hope that I can write to make such a question. Sorry, you can inform because you inform us that competition commission could change everything and even without making reasoning. So I don't agree with such a presentation. And so I would like ask you for making the verification. What is your why you make such a wide interpretation of the role of the competition commission, which is, in my opinion, not in the line with law.
Well, first of all, I would like to emphasize that within the format of this interview, you have no right to demand my explanation of the legislation, the part of activity and competence of the competition of selection commission.
You to make a verification because you did it.
Вибачте,
I'm so sorry. I was asked the question about in what way were the decisions made by the commission. So I provided my reply. But going back to my statement again that I have already expressed, I think the situation being absurd that when there is a body that in fact has to automatically approve the decisions of the Ethics Council. That statement has already been made by me. In the part of your words that the decisions were unreasonable or without grounds, I categorically disagree with this. In certain documents of the Competition Commission, all of this has been specified, and you can familiarize yourself with them. Thank you. Madam Hannah, are you satisfied with the reply? Madam Sukotska, could you please switch on your microphone because we can't hear you?
Yes, I said that no, I have no more question.
Дякуємо.
Thank you. Allow me then, Mr. Zakhar, to proceed to the next section of questions related to your scientific activity and your professor activity. In 2008, you defended your PhD thesis on the topic, the mechanism for resolving international disputes under the Energy Charter Treaty. Taking into account the fact that some of its fragments and references to other sources raise questions, we invite you to comment on them, if you don't mind. And question number 1. The source of Professor Janik's opinion, your dissertation, is source number 162, which is a collection of articles by various authors. At the same time, on pages 43 to 58, it contains an article by Professor Janik, International Trade Conflicts Before the Permanent Court of International Justice and the International Court of Justice, where this opinion was probably expressed. So, this paragraph 1 of the table that we have provided to you, and can we show this table on the screen? So here we can see So that's very similar by its content with a quoted paper by Jake and your material that you used for your dissertation. So the question is, why is there no reference to the article and its author and the author, Professor Janik, in the source? The reference is in the text. It's black and white. It says Professor Janik's mentioned. So the quote that this his thought. As for the use of the source 162 and the work of the participant in accordance with the rules for the materials and the sources of the literature used, I was supposed to specify the source but not the specific article back then. Moreover, this source could have been used also in other parts of my paper with references to the articles of other authors. Thank you. Next question. In the list of used sources of your dissertation, there is article number 165, but there is no reference to it in the text of the dissertation itself. That's paragraph 2 of the table. Let's show it on the screen. Do you confirm this information? For what reasons was the source not included in the list if there are no references to it in the text of the dissertation? In accordance with the requirements that existed at that period of time, the list of literature, it was not obligatory to include only those sources that were used for quotations and for which the references are in the text. I could specify all sources that I have processed or read preparing. And another important thing, there is also the technical moment. Just for your understanding, you asked me these questions in written, and I was checking on my drafts when preparing for the dissertation, and I had the block of the draft files for my dissertation. I had 4 editions of the dissertation and 4 also publications, well, not publications, and 4 drafts of the amendments. And back then, as far as I remember, the requirements to the description of the sources of literature would also change. So I was also changing it because of the change of requirements. So in this part, this list of literature was generated along the work on the dissertation. So please consider that even though the topic is very simple, this topic is rather complex, the mechanism for the international dispute resolution, because it includes at least 5 directions, and you had to investigate literature per each of these directions. And in fact, these were separate spheres of international law. Please give us the answer. Answer the question. All the technical reasons, because of technical reasons. Because the list of literature was generated along the work on the dissertation. Okay, so then tell me please, how many sources are there in your dissertation that are in the list but to which you do not directly refer in the text itself? Can you remember? Well, to do this I have to review my dissertation, but I'm sure given the volume, I'm sure that they are there, given the way I worked on this dissertation and the change of the requirements. The Commission has analyzed your dissertation, and according to our calculations, out of 201 sources indicated in the list of references, only 115 are referenced in the dissertation. So the other 86 sources are not mentioned in the text of the dissertation. Do you confirm this information? If so, why were such sources included in the list of references? If you didn't reference them, why did you include them in the sources? I cannot either confirm or refute this, but I of course trust the conclusion of the Commission if you did calculate. But the reason is the same that I already highlighted. Big volume of work and many amendments and changes that had to be made and the formal amendments. And also a lack of the formal requirement in this part. I would like to draw your attention to the fact that in that period of time we did not arrange our list of literature in accordance with the order that it has been mentioned in the text of the dissertation, but alphabetically. Thank you. And you have many references in the text of your dissertation to Mr. Petersmans, mainly his works dedicated to your problematics. Can you explain the degree to which you have been quoting this author and your level of interest in this author? Yes. Okay, maybe I have to talk about this separately. After I got the questions and answering the questions in the part of my dissertation, I, in very much detail, would go through the draft of my materials. And speaking about Petersman, in fact, there is one paper that is important that was used in my dissertation for my dissertation. Just a second. Number 162 in my list of literature. This paper was used. If you used it, why there is no reference in your dissertation to the author? That's exactly what I wanted to explain in this context. Given the way I worked on the materials, when I took a look at my draft materials, I translated the articles in order to use them in my text of the dissertation. And the translation was done of some parts with certain quotes that I would use. And mainly it was the paper by Petersman. And it was later on used in the text of my dissertation, that translation that I was referring to. But there were certain references, but given the reformatting of the text, I lost the references, and I had, if to be specific about article by Petersman, there were two issues there. The references to norms and regulations, he had the NAFTA agreement reference and the conventions exceed, if I'm not mistaken. Plus, the things that I have translated with the sources that was used by Petersman. And correspondingly, maybe at some moment I lost this reference, but when finalizing the text, not even at finalization, but the further work, I checked the references to norms and regulations, and I would insert them. But with the references to the authors, I just thought that these were the correct references, so I just followed along the text. I was thinking that these were the right references. So if I understood you correctly, you were using the works of Petersman, but you didn't specify the source from where you took the information, only about this one paper. I would like to emphasize on this, the one that is under number 163, and it's only maybe 2 or 3 pages, the translation of which I used. Dear colleagues, you have questions. So could you please tell me, in what years did you prepare your thesis? In 2006, 2008?
And I continue this scientific work. The next block of questions will be asked by Pani Hanna Suchocka. Pani Hanna, please.
Some more questions.
Це блок номер 7.
This is block number 7. If you do not have this block available, I can start.
I have.
And then we close it. Then it gets closed.
У мене немає. He's not close. It's concerning his education in Чернігів University.
Okay, go ahead. You're
Right.
asking.
Пані Ганна, вас немає?
Pani Hanna, do you have the block of question number 7?
Sorry. No, I have. I am speaking, but I was microphone. I had microphone off. Now it's okay. I hope. I start again.
Дякую.
In 2012, you restored your fourth year of part-time study at the Chernihiv State Institute of Economics and Management. And in the same year, you received a bachelor's degree in law. Subsequently, you entered this institute for full-time study, and on 26 June 2013, you received a specialist diploma, having received the qualifications of a lawyer. However, by that time you already had a complete higher education in the specialty international law, which you received in 2006, and Field of Doctor in Law, which you received in 2009. Why did you decide to get an education in the specialty jurisprudence? What was the reason to make this study?
This is the situation that still raises a lot of questions among my colleagues. The issue was that at the time, part of the legal community does not acknowledge the specialty of jurisprudence as part of the legal education. When I was going through this educational process, I also encountered several legal obstacles. This was the reason why I could not go to the association at Kiev, because back then my diploma was not valid there. Right now, the specialty of international law allows you to apply for the license of attorney, but back then this was not the procedure in place, and this could not be decided or resolved in Ukraine. That is why I went to Sumy, where the specialty of international law was eligible for the license of the attorney. And in order to resolve these issues in the future, and in order to remove any formal obstacles that would not allow me to practice law, I decided to get an education in the specialty of jurisprudence.
Yes, but you decided to go to Chernihiv State Institute instead of making the study in Kiev. Yes, why you didn't choose an institution in Kiev where you permanently live and work? What was the reason for going to this specific Chernihiv Institute?
Причина була
The reason was, so the primary criteria for me was that it was supposed to be a state institute, and also I wanted to go for the full-time studies, as well as I wanted to get an affordable cost of the education. For me, this was critical back then, because I did not have sufficient funds, which the information that I already disclosed in the part of the questions that were limited within the broadcast. However, according to these criteria, the affordability of the education and the opportunity to go with the full-time studies, I decided to choose the Chernihiv State Institute. I found out about this opportunity from my mother. She learned that I wanted to get the education in the specialty of jurisprudence, and she told me that I could apply to the Chernihiv State Institute.
Inform us, in your written question, you informed the advisory group that it was the your mother advised to go to the institute. But you also indicated that your mother provided you with organizational and informational assistance. What kind of the assistance you received from your mother? What does your mother help during the study in this institute?
Як я і вказував, це
As I have specified in my answers to the written questions, this was the act of submitting the document to apply to the university. For example, the application for the master's thesis was supposed to be submitted in person. I was supposed to go from Kyiv to Chernihiv and then to submit this application in person. Instead, I would just go to the bus that goes from Kyiv to Chernihiv. I would give the driver my application. My mother would receive the application from the driver in Chernihiv and would then bring it to the institute. This is how she helped me in this process.
можна я задам?
Allow me to ask a question.
No, I only would like to ask you if maybe don't you think that the help of your mother can give such an impression that only for that reason you went to the Chernihiv Institute, yes? How you see this situation?
Я не думаю, що це можна витлумачити як надання.
I do not think that her help can be considered as some sufficient help. She was just helping me with the things that were supposed to be done in a different city. She did not help me in the educational process, and did not know my mother well. She would never help me in the educational process itself. She would never interfere with my educational process. Her principal position when it comes to education and scientific work is that you are supposed to go through this independently without any help.
Okay, thank you. I have no more questions.
Колеги, є питання?
Dear colleagues, any other questions within this block of questions? You know, with all due respect to you and to your mother, unfortunately, we do not know her personally. We still have certain questions. In your answers to the written questions, you said that in 2012, you restored your 4th year of part-time study. Could you tell us how you can restore your year of studies if you did not study in the institute before this? This is my first question. The thing is that I was studying at the State Tax Service Academy, and when I transferred to the university for the specialty of international law, I did have the notice that I was studying in the specialty of law enforcement studies. So this was the reason and the eligibility for me to restore my studies. You know, luckily, I have 40 years of experience in a educational institution, and I do know the peculiarities of the process of restoration. I will tell you that this fact of restoration raises certain concerns, but we will not deny this fact. So you restored your 4th year of part-time study, and typically the restoration does not happen for the last year of studies. Typically you need to pass certain exams to be eligible to restore the studies in the last year. And just a couple months later, you receive a diploma, a bachelor's degree in law. So if you were restored, you were supposed to be restored for the 3rd year, and then you would receive a bachelor's degree a year later. That is why you will always have questions regarding this. Now, you enrolled in this university for full-time studies, and in 2013, do you remember the month when you enrolled in the university and when you received the diploma? I studied for 9 months because the term for studying for the specialist diploma is only 9 months. I understand this. So you were studying full time, you were living there, you were attending the lectures. So here we have two questions that I would like to answer. The first part of the question regarding the restoration, I believe that I need to answer this. First of all, I did have an academic notice when I was practically at the 4th year of studies from the State Tax Services Academy. I was legally restored to my 4th year of studies. That is why the restoration to the 3rd year of studies would not make sense, because a lot of subjects were already studied by me and they were verified in the Chernihiv State Institute. I did have sufficient number of subjects that I could easily pass during my 4th year of studies. When we speak about the restoration, it is typically based on the academic notice, and then you need to pass the exams on the subjects that were not included in your previous program. But the commission checked the number of subjects that I studied at the previous institution, and then I passed the exams on those studies that I have not gone through. I also wanted to say that this is not the question of someone helping me. This was in accordance with the requirements, legal requirements and documentation that I provided to the Chernihiv State Institute. Now, regarding the question about full-time studies, I did answer this in the written questions to the advisory group. Initially, for me, it was important to be enrolled to the part-time studies. However, when I received the bachelor's degree, I started thinking how I could continue this educational process. And for part-time studies, only master's degree was available, which would take approximately 1 to 2 years. And there was also a specialist degree that could be completed within 9 months. So I decided to go with this option. For me, it was difficult to start full-time studies, and I did request an individual schedule of studies, and therefore I was completing the tasks assigned by the lectures according to my individual schedule. This is still not convincing for me. Based on what I know, based on not knowing the grounds for your restoration, if you had the academic notice, you were supposed to receive the academic notice for the 3rd year of studies. I completed the studies of 3 years and I was transferred to the 4th year. Yes, but restoration at the 4th year of studies is not the procedure that takes place in the educational institutions. The restoration can only happen for the 3rd year of studies. It can only happen in the case when the person was already studying at the 4th year of studies in this university, and he or she would like to restore the studies in the same university. But the transfer from a different educational institution does not imply the restoration to the 4th year of studies. First of all, this was not the fact of restoring the studies or transferring from the previous institution. For me, to restore these studies, there were no limitations to restore the studies in a different educational institution if the new educational institution had sufficient licenses. Yes, but you did say that these were two different specialties. Yes, but this is the same sphere, which is jurisprudence. I have no further questions.
In the interest of time, I think we're going to conclude the interview at this time, and I'm going to give you the opportunity to make a closing statement here, Mr. Tropin.
Ну, хочу сказати, що це був для мене дуже цікавий процес, який так і
Thank you. First of all, for me, this was a very interesting process, and I have never in my life encountered such a thorough research on my biography, and I am quite satisfied with this, since the facts that were presented by AGE, based on such thorough analysis, pose everything that can be used to question me. I believe that I do have the quality of integrity, and I do believe that AG will be satisfied with my answers and will also make a positive decision on my candidacy. Thank you. Thank you. If there are no further questions, we will announce this interview to be completed.